All right, so good afternoon to everyone. Welcome for the second panel. It's great that you haven't left. So it seems kind of interesting. And following the first panel, whose objective was to discuss about the extent of the problem, if there is a problem in terms of capture and corporate funding of competition law and policy. The objective of this panel is to look to the way the competition authorities and the courts, the adjudicators, are dealing with the perceived risks of bias, in particular material bias, because as many of you noticed during the first panel, the competition authorities and courts have been confronted to issues dealing with party expertise for almost like 150 years. I mean, there has been a very interesting article by Learned Hand, the Harvard Law Review, back at the beginning of the 20th century concerning the concept of party expert. So courts and judges and competition authorities a little bit more recently have been dealing with issues of bias, and I think it will be quite interesting to hear from their experience. So we have a quite interesting panel here, a mixture, equal mixture of competition authorities staff and high place staff, and also judges, both economists and lawyers, which I think is quite interesting, both sides, and also coming from both Europe and the United States, so presenting a little bit this cross-jurisdictional perspective on the topic. And I think, we have been dealing with party experts, but increasingly as well with policy briefs submitted by third parties supporting one side in litigation, as well as also academic commentary, which is referenced in party submissions quite often, and sometimes also referred to by the courts or by the Advocate General in the EU. On authorities and courts obviously cite such academic work in their decision, potentially also increasing the policy impact of those publications. And some of this work, sometimes even work that has been cited by the courts, has received funding or support from corporate entities directly or indirectly. And of course, competition authorities form part of larger networks, international networks, or international organizations. We have the ICN, we have OECD, we have UNCTAD, would organize public events and meetings with academics and practitioners. Judges also, they have their own events, the Association of European Competition Law Judges being one example. Where also, again, issues of disclosure and of material bias might appear because, of course, we have a number of academics, eventually also people that have been participating in consultancy work that contribute to these programs. And finally, we have also quite a lot of judicial training going on where you have some of this organized by centers which have been funded by corporations for a long period of time. So that obviously raises quite interesting questions about the way the courts, first in their adjudicatory type of work, should deal with issues of bias research. What are the procedural and substantive rules that they develop in order to deal with this type of asymmetry sometimes that might exist between the defense and the plaintiff side? And also what happens with the rest. I mean, all the other types of involvement and public involvement of judges and competition authorities. Should we develop new rules concerning the ontology about these issues? So this is a little bit some of the questions I would like to discuss with such a great group of panelists. So we're going to start first with the competition authorities. We have Ana Sofia from the Portuguese authority, who is an economist, Damien, Director General of the Belgian authority, who is a lawyer, and Fernando, who is a litigator, a public litigator, representing the Commission in many cases at the court. So let's start with first statement about how do you think, is there a problem? I mean, do you feel that competition authorities have developed mechanisms to deal with that issue? Anna Sofia.
So thank you so much, Ioannis, for inviting me, and congratulations on putting together this event. Actually, I was trying to think when such issues were discussed in open fora, and except for late ACE last year in Milan, I couldn't remember another fora where such discussions were held. And then in our day-to-day work, agencies, when we try to find, if you try to find readily available sources that can give you some insights on how to deal with some of these issues, there's very little. As you mentioned, there's Ascola that was already referred in the earlier panel, but there's not a lot out there that can help you optimize your decisions. And this is surprising because identifying and preventing conflicts of interest is a core concern in the activity of competition agencies, of course. There's many tools, many measures that we take to prevent that. But it is, of course, the topic that was discussed earlier in the panel. To some extent, it's not something that we can alone solve, of course. We can advocate for it. And we can do some measures around the edges to mitigate the problem that was mentioned in the first panel, and that's what I'm going to address too. So, first, I'm going to address those measures, bearing in mind that they refer to conflicts of interest sometimes more broadly, so they're not absolutely or completely directed to the points that have been discussed. Then I'm going to discuss a bit the procedures in court. In two instances in which there was an economic assistant that has been appointed to assist the court, and I'm going to go through the procedure that was followed in those two cases critically so that we can share experiences. I think sharing experiences is very important. And then finally, I'm just going to wrap up with some comments in, overall where we are and where we lag, what we need to do. Now, regarding tools on conflict of interest within the ADC, as I mentioned, this is a core concern for us, and there's many tools. There's a code of conduct for ADC staff, which we reviewed last year, and for which there is staff training. Maybe more importantly, related with the previous discussion, there's a regulation regarding conflicts of interest for external service providers that was approved in 2022 and reviewed already this year. And this regulation, among other things, establishes the rule that these external service contractors need to observe in front of the ADC regarding conflicts of interests. It said that economic and legal consultants cannot hold any link or contractual relationship with anyone or any company, hold any shareholding or interest or any relationship which could give rise to a conflict of interest. This means that upon for the provision of services to the agency, they need to declare, to sign a declaration that none of these conflicts of interest are present. And this includes on academics and consultants that produced reports to the ADC, who are required also to submit this declaration. Now, the ADC does almost all of its economic analysis internally, but occasionally it has resorted to external consultancy services for very well scoped exercises and tasks, in particular merger simulations. That's the most common. This was the case, for example, last year when the ADC blocked the telecom merger between Vodafone and Novo, and in which also we were faced with a narrative that was developing, again by CEO telecom companies, regarding the claims of that we need Lex merger enforcement in order to achieve scale and investment. Now, there was a discussion earlier on narrative, and I think there's something we can do, which is to seize momentums to help consumers and citizens and policymakers understand what we do. And following the decision of the authority to block this merger, we were faced with failing firm defense. The media was full of claims that if we would not approve the merger, the target was going to go out of the market. So it was a very heated the public debate. And then at the end, the fact was that after the decision by the agency, there was a newcomer, a new entrant that acquired the target, and prices went down very quickly. And on those moments, you need to seize the opportunity to show the benefits of merger enforcement for society in general. And this is on narrative. So not creating a narrative necessarily, we need to be impartial, but still we need to seize the moments that help illustrate the importance of what we do. Now, then apart from that, there's a lot of, I was thinking, there's a lot of decisions about a lot of measures, a lot of reflections that we have internally to try to minimize conflicts of interest. For example, we try to minimize the risk of biases in the training process and in the way that we are exposed to the competition ecosystem. We favor experts to provide in-house training to the ADC staff who are renowned for their unbiased stance to the detriment of consultants, for example, in both training and our long-standing seminar series. Regarding outside trading, what we do is that we invariably check the trainer's profile and background. Does this solve everything? Of course not, but I'm discussing what we can do and how we can try to minimize the issues. We also favor events and conferences where there's a multilateral views represented and an open debate. Now, Tommaso was speaking also about engagement with stakeholders, and this is something in which we are currently, not only last year, but this year, very engaged in advocacy interactions with different stakeholders, and that includes trade unions, worker unions that already participated in public consultations with the ADC, but also startups. This is one of the focus of our advocacy initiatives this year and a particular campaign that we are launching. Let me now refer a bit to courts and to the two experiences that I mentioned earlier. There were two cases in which there was, because of their complexity, an economic expert was nominated to assist the court. The process is as follows. The judge invites the 4 or 5 most preeminent universities in economics in faculties of economics in Portugal to put forward names for potential economic advisors. The court sets out exactly the scope of the intervention, which usually boils down to attending court hearings, providing the necessary input, and at the end produce a report that answers to the economic questions that are put forward by the court. And then the parties have an opportunity, both the Portuguese Competition Authority and the undertakings, to react to the candidates and to their impartiality. And then the judge nominates one out of those candidates received. In terms of requirements, the candidates need to be knowledgeable on the substance matter. They must be a person of I'm reading what the court says. A person of unequivocal good reputation, capable of preserving business secrets. They must not have any personal interest in the case, arising in particular from any past professional relationship that could jeopardize their current impartiality with either the agency and the undertakings, nor can they have any family ties with persons who are legal representatives or have managing power on the undertakings, nor have any judicial or non-judicial conflict with those entities. These impartiality requirements apply not only to the undertakings, but also to the rivals of the undertakings. And note that in one of these cases, the judge required the advisor could not pursue any professional activity other than teaching or academic research. Now, to finalize and to wrap up some thoughts about the discussions that were held, I think that economic research is absolutely crucial to guide and enlighten the work that the competition agencies do. There are many developments in research in the past, papers that have marked towards where we're going. I'm just mentioning too, the killer acquisition paper was absolutely influential in the discussions around regulation and competition policy enforcement that followed. But also the macroeconomic empirical results regarding the labor share in GDP were also highly important in as a wake-up call that turned the eyes of agencies towards labor markets. Interestingly, this last one did not came from IO economics. And I think regarding the feedback loops between research and policy, what I think is that Aviv was noting that research does not exist and publications to serve competition authorities or the application of competition law. However, of course, that this detachment has implications. Right now, we need to discuss fully how to design and deploy industrial policies. And if you look at the literature, there's so few literature on evidence on the impact of actual industrial policies. There's some anecdotes, but there's few solid evidence that can guide our work as in the wider public policy discussion, because we don't do industrial policy, of course, but we should advise on industrial policy. Now, thinking a bit, given that this huge importance of research for our work, I think that the discussions that we were having earlier and the fact that we are lagging in terms of rules of disclosure can have important implications. I think that the impacts that Tommaso mentioned earlier of the risk aversion from agencies because they do not have access to full information is important. I think we need to know whom we are speaking to, whom we are listening to, and whom are we reading from. And there are gaps here. If you think how often do we listen to conferences in which we do have a perception that there's conflicts of interest that are not being clearly stated? How often do we read court rulings in which sides a given economics or legal scholar without whom we know that does private practice, but is referred to as a professor, and this is not taken into account. So I think this is something that we need to address. Otherwise, there's a loss of trust in research, and that can have a negative impact for the work that we do. Now, at the same time, this is about information. This should be no obstacle to an open debate in which different views are exposed. Otherwise, you are closing hermetically agencies and courts in glass boxes, which can only work for confirmation bias, will not make us stronger, will make us weaker. Thanks.
Thank you very much, Sofia. Very interesting comments. I was very interested by your regulation concerning external services. Because as you say, we need, obviously, first there's an issue of resources. I mean, we don't necessarily have the resources in terms of quantity of people. I mean, when I joined the Greek authority, I mean, there was actually one person, or even not completely, was an econometrician. So, I mean, how can you do a competition law and policy without having, a number of econometricians? So we needed to get external expertise. Quality also, I mean, you have much more specialized expertise that you need to be able to get. But the question is then, and the openness also, that you want to have an open authority. But how strict are these rules that you have? Because is it really that the specific expert should not have any conflict, or are you going also with regards to the consultancy they're participating at? Because if that's the case, because there are very few consultancies, I mean, you might end up basically having much less access to external expertise. That's a question, practical question.
Yeah, practical question. That when the last time that we had these consultancy services was an open procedure, so there were some proposals that would put forward, and the rules were for the people that were going to be involved. I don't recall, the ones that I stated are how they are prepared. The fact and the reason also why I was so detailed in reading this is because sometimes we need experience sharing to understand where possible gaps may be. It's not always transparent. You read something and you say, oh, this is so defensive, this is a very protective, and then there's an angle like that you might miss. In the specific case, however, this was not relevant because it was a solo consultant, so it was not. Yeah.
Also, I was finding very interesting what you said. Somehow it joins some of the speakers this morning, earlier this afternoon, concerning the fact that a lot of the novelties that we have seen recently in competition and policy don't come from IO economists, but come actually either from people that are working on business studies. I'm thinking about ecosystems or the work on capabilities, or people that are labor economists, or eventually sustainability economists, now that we're moving all towards that. So the question is how you can open up the competition authorities to this also type of wisdom from economics. And maybe Damien will have things to share about that and other things as well with regards to the work you've been doing, excellent work you've been doing at the Belgian authority the last couple of years.
Thanks, Ioannis. Thanks for the invitation. And again, this is a very important event. It's a very courageous topic, obviously. It's a complex one. It has many ramifications, as the first panel exemplified. But so obviously it resonates with, I think, both an overall tendency in our epistemic community, towards somehow, and I'm here citing other people like Sarah Cardell, for example, who is not the most extreme person out there, observing a degradation in the quality of submissions received by authorities, by competition authorities, whether from the legal or the economic side, probably a reflection of the interest at stake. But it also obviously resonates with more broadly current world affairs. I don't need to describe things here, but there is an obvious connection between bias, capture, manipulation, distrust, and the issues of freedom and the rule of law, which are the bedrock principles of our liberal democracies. Now, just a side note, it's really nice that obviously the Stigler Center is associated with this conversation. Stigler having obviously been the one identifying or at least formalizing the notion of regulatory capture and having developed it. But I'd like also to bring to your attention a slightly or complementary concept that was developed by a young colleague of us, Jan Brolik, a few years ago, the notion of cultural capture, which I think is also important to our field, our epistemic community. Now, Ioannis asked us to discuss how courts and competition authorities assess the risk of conflict of interest, particularly material bias. And I have actually interpreted material bias as bias of sufficient magnitude to have a notable impact on the results or conclusions of a case, right? And so you ask also to what extent this is a problem and the procedures and substantive rules in place to address such conflicts. Now, I will disappoint you, Ioannis, because I'm not going to talk about, possible bias in, party experts' opinion. I'm going to be much more, direct and point to a much more problematic issue, which goes to institutional design. Because we still have to talk about, these issues of conflict of interest, which have a direct impact on the decisions we're taking. And hopefully this brings a complementary perspective to the other conversations we're having today. And I think it's also attuned with the evolving geo-economic context in which competition enforcement takes place these days. But so, yes, institutional design is extremely important because it can actually put certain competition authorities at the mercy of some undue influence on the one hand, and it can also be conducive to solutions to certain risks of conflicts of interest. And I'd like just to recall the framework in which we operate in Europe, and then I'm going to explain to you a bit how concretely, based on our experience in Belgium, it can have a serious impact. Now, the broader framework in which we operate in Europe is the ECN Plus directive, right? So we have this piece of legislation that actually mandates the independence of national competition authorities as a condition to ensure not only effective enforcement, but also cooperation, between competition authorities at EU level. And what's really interesting is that the ECN Plus directive doesn't talk only about independence from political influence. It's much broader than that. It says, that member states have to make sure that competition authorities are protected against external intervention or political pressure that is liable to jeopardize the independent assessment of the matters before them. And it's not only about, so as I said, political pressure, but also any kind of external intervention. So as to remove any reasonable doubt as to the impartiality and the imperviousness to external factors in general, right? And these guarantees have to apply not only to heads of authorities or staff, but also to anybody who takes decisions. Because in Belgium, but in many other national member states, you have people taking decisions who are not members of staff and not, the heads of the authorities. And obviously, there are not only obligations applying to member states, but also obligations to individuals like myself, like my other colleagues here from the Belgian Competition Authority, to the effect that obviously we should refrain as individuals from any incompatible actions, whether gainful or not, both during our employment or term of office and for a reasonable period thereafter. Obviously, so we have to avoid, putting ourselves in situations of conflict of interest, and so DCN Plus directive also mandates a discipline at our level. And I'm not going to go into the details. You can imagine the types of rules of conflict of interest that are mandated by the ECN Plus directive. They actually, I think, are not complete enough. I think there are gaps there. They don't tackle, much more diffuse conflicts of interest, issue conflicts as they are often described. I think there are still ways to, improve the framework, but at least it exists, and it can certainly have significant consequences. Importantly, the ECN Plus directive also mandates every national administrative competition authority to publish a code of conduct that covers rules on conflicts of interest. And so there you can obviously complement also what the ECN Plus directive provides for. And actually Article 4 of the ECN Plus directives stresses that these are minimum rules, right? Member states shall, at a minimum, ensure that blah, 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 all right? So, and interestingly, in Europe, we also have case law on the notion of independence and the requirements of independence. So in 2022, we had the SPED Pro case, right, by the General Court, which has, obviously identified that systemic or generalized deficiencies of such a kind as to compromise the independence of competition authorities can actually have, direct consequences for third parties, also for the rights of third parties. So, and concrete implications also in terms of application of the cooperation rules, which can go all the way to depriving a competition authority from jurisdiction. That was the issue in that case, and more generally pertain to due process issues. I'd just like to mention that there is really interesting literature by people like Cathy Cheres and Maciek Bernat on this, in which are really making the link between the role of competition authorities and I would say the constitutional role of competition authorities in our social market economy model in Europe. And with the importance of the independence of these competition authorities as being really a critical factor in enabling competition authorities to fulfill that constitutional function, and thereby also contribute to safeguarding the EU rules of law values. We also have case law on the independence of, for example, data privacy regulators, extremely interesting as well. Independence being interpreted very broadly as freedom from any external influence, going beyond operational independence, but going all the way to include any type of political influence, but also any suspicion of partiality that can be result from all types of influences. So my point is that so we have a framework in Europe which I think can be actually stretched quite far, can have real consequences legally, and certainly mandates a number of obligations for competition authorities and for member states. Right. And I think this provides, in fact, a useful framework to try to achieve immunity from material bias. Now, I'd like to just illustrate, how it can translate in practice, in a framework of, of my competition authority, which is, in a country that has a long-standing tradition, and a relatively well-working, state structure, and actually, I do think that we are very much independent from political power. But still, we have a system which is designed institutionally as a two-tier system. So we have, on the one hand, the investigative level, and then we have the decisional level at the level of the college, right? The college is competent to take any contentious decision, both in merger control and in antitrust cases. The system causes all kinds of delays. That's not the point. That's not the issue to be discussed today. But how is the college composed? What's the composition of the college? Is the president, who is the only actual staff permanent member of the college. Otherwise, non-permanent members called assessors. There are 20 of them. And originally, the system was designed, apparently to guarantee the independence and the quality of the decisions taken by the authority. But among these 20 people, you have 6 academics, all good. But then you have 8 lawyers in private practice, 2 economic consultants, 2 in-house counsel, 1 former enforcer, and 1 judge. All right. So 12 members out of the 20, actually, just more than half, whose main job is to act as counsel to companies under investigation before the authority. Right? And sometimes in very, very contentious matters. Now, it's a very diverse group of people. I'm not pointing fingers here. That's not the purpose of my message. But what we see is that there are recurring patterns. And more importantly, it does create a risk of material bias. And a very direct risk, not indirect. The risk is that of a direct influence on the practice of authority, both on substance and procedure. And frankly, I cannot disclose that, but I have concrete examples here, right? Both on substance and procedures, where clearly the college could have decided in another way. All right. Also, what we observe is that some of these non-permanent members, they openly criticize the work of the authority. In academic journals, on social media, and then you're supposed then to face them a few days later as independent member of a panel that will decide on an investigation that's been running, for years, and in which you've invested very, very significant resources. So, yes, there are incentives based essentially on the other activities that these members have, and probably for most of them, these are also very much unconscious biased, right? And these biases are compounded by how the system is structured, because these people are obviously by construction excluded. They cannot be involved in the investigation that led to the case. So they're not aware of how all the case was built and how eventually it ended up the way it is being presented to the college. And I think the system is designed as such as to be very much, as to make these individuals very receptive also to biased and incomplete arguments coming from other parties, that is from counsel and experts to parties in the cases in which they're going to decide. Because they've not been involved in the whole investigation, because they have limited time, and because obviously they have other activities which are very much linked or can be very much aligned with the parties arguing the case in front of them. So I think it creates a very high risk of capture, a risk of taking shortcuts, and that's not sound. So what are the safeguards, right? Well, first, information is obviously super important to be able to identify conflicts of interest. up until now, the information that was asked from these non-permanent members was very summary on an ad hoc basis. Now we're working to elaborate the system to just make sure we are aware of all the information relevant to assess whether they can be in a position of conflict of interest or not. The second point is, okay, next to information, exposure of these conflicts of interest. Well, they are very high cost to expose these conflicts of interest, because I'm taking a very big risk today in talking to you openly about this. But imagine, the risk I'm taking when I'm actually, sending a letter out there or confronting a member of the college with the fact that he might actually have a conflict of interest that has not been disclosed and that he shouldn't be sitting there. What is he going to think the next time I bring a case in front of him or her, right? And so there are different ways, anybody can actually report the situation to the president, but the president, he's actually interacting on a daily basis with these individuals, or we can confront the person directly, but the procedure is quite costly. And then the third question is a question of remedy, but not obvious at all either. Going to the termination of removal of these people, very long shot, and obviously creating a lot of risk as well. Abolish the system. Well, maybe we should think about that. I think the authority is also mature now, and I think we can probably, starting maybe with concentrations, think, or at least open a conversation about the need to reform the system. We can obviously also create incompatibilities between, certain people holding certain positions and having the possibility to actually be appointed as assessor, talking about cooling off periods, etc., etc. So my point is that I don't want to point finger at anybody here. That's not my point. But I think at Belgian level, we need to open that debate and probably to rethink the model, just to pursue this objective of effectiveness, which is at the core of the CN Plus directive and the requirement of independence that it mandates. And I think in recognition of the fundamental roles that competition authorities exercise in upholding essential values, to our society and to the rule of law.
Well, thank you very much, Damien, for these very brave comments indeed. In Greece, actually, we do have two external members that eventually and sometimes have been practicing law at the same time, or economic consultants, out of the 12 members, so it's much smaller percentage. Usually we ask them to disclose every time there's a case which is introduced in college, any conflict of interest, to recuse themselves from that. There's an obligation with also criminal kind of liability in case they don't provide this information. But I think it's interesting to point the issue about how to organize a college, how to be open, because you don't also want to have only competition authority people that are moving up to the college, so that creates a different type of bias. So you need to have an authority that is more open to the external world as well. But again, there are different systems we can discuss about this, but it's definitely quite an interesting point that you brought forward. Now I'd like to move to the courts and make the long trip to Chicago. So we have a Judge Wood with us today, a very extremely experienced competition academic and a judge as well. And the US system actually is pretty interesting, the way that he has been dealing with material bias. You have the possibility of court-appointed experts. Not sure that possibility has been used many times. You have actually the so-called admissibility step in the assessment of evidence with the Dobbert rules that have been used quite a few times actually for a number of economic experts. So it's quite interesting to see. I was looking at some of my research like 10 years ago to some of these cases. These are pretty interesting cases looking to the different criteria that have been used compared to the Frye jurisprudence in the past in Dobbert. And also, you have the substantive assessment of that economic evidence by judges. So you don't have specialized courts in the sense of the Competition Appeal Tribunal, but many of the judges in particular circuits are extremely specialized or experienced in area of antitrust. But then you have also more journalist judges that deal with very high-profile competition cases. Can you share a little bit your experience with regards to the way the U.S. courts have been dealing with all these issues and procedural steps that they have taken to deal with material bias? I hope you can hear me.
Yes, I'm very happy to do this, and I should begin by thanking you for not only including me, but accommodating my inability to fly over to Brussels for this program. Zoom has its uses, I think, and I very much appreciate it. So you're quite right in terms of the way information reaches judges. First of all, a case is going to begin before a generalist federal district court judge who might have had a background in the U.S. Attorney's Office prosecuting drug cartels, or maybe they've been doing civil frauds or whatever they've been doing, and then suddenly an antitrust case falls into their lap. So there are a couple of things the judge is going to do. The first thing is to administer the rules for expert witnesses as well as the judge is able. And as you said, that really began for modern times in the Daubert case in the early 1990s. That was codified in Federal Rule of Evidence 702. And what that rule calls for is for the judge, first of all, to assess whether the person really is expert in this field. I mean, there are plenty of people who might self-promote as experts, but perhaps they really aren't. So the judge will look at the background, will look at the amount of time that the person has spent on this particular kind of issue, and you can be an expert either by training or by experience. So you might actually have an industry expert who isn't a PhD from someplace, but who brings a lot of insight into the way a particular restriction might operate within a market. Or you have, of course, your academic experts. And I'll pause on that for a moment and just say, I want to come back to how that academic expert has expressed their views in the past. But first of all, are you an expert? Secondly, did you apply your expertise to the problem at hand? So even a generalist judge can get some sense of that. You know, here's a problem. What did you do? Did you spend a weekend just reading a few things and then writing up a quick 2-page report? Or did you really apply serious academic tools to understanding the problem? And of course, the most famous case that turned on that second step was one by my former colleague, now retired, Judge Richard Posner, who in the brand name prescription drugs litigation was asked to evaluate testimony that Professor Robert Lucas had given. Now, Professor Lucas had recently won the Nobel Prize for economics, so I don't think anybody doubted that at step one, he really was expert. But at step two, the question was, did he bring his expertise to bear somehow on the case? And Judge Posner wrote, well, the only thing he said, basically, was that if prices go up, people aren't going to demand as much. And he said that's not particularly, earth-shattering or useful or anything. So he actually excluded Professor Lucas's testimony from the case, just said it didn't pass step two of Daubert, or Rule 702, if you will. So there's that step. And then if you get past that step, the judge is not supposed to decide whose expert account is more persuasive. That's for the trier of fact. And so that, in a case tried to a jury, would go to a jury. So you're going to have party expert on the plaintiff side, party expert on the defendant side, and the jury will decide questions of the weight of the evidence, as we would put it. Not the admissibility, it's come in, but then how much do you rely on it? So let me go back to the question of how the expert has worked in the field before. In our universities, I think it is increasingly the case that if somebody has received funding for a particular line of research, or if maybe even a paper was commissioned by someone, you will disclose that in a footnote at the beginning of the article. I'm thinking of my friend Sam Sakharov at NYU, who's a well-recognized expert in complex litigation. And there'll be a footnote if Sam was counsel for a party in a case that was discussed, or if Sam received some kind of stipend to support the collection of data, or whatever it might be. So even at the level of the academic article, there is a norm of disclosure. Not a rule, I'm pretty sure, but certainly a norm, and the university itself would expect that sort of thing. That's a theme that's going to run across everything we do, because disclosure is, I think, maybe the strongest tool that the U.S. courts will use. So you mentioned briefly court-appointed experts. Yes, our federal rules of civil procedure allow court-appointed experts. No, we don't really use them. I can almost recite to you on the fingers of one hand the number of times that has been used. I'm not quite sure why it's so unpopular, because the parties are already spending a lot of money paying their own party experts. It really can't be that you're just dividing the cost of the court expert. When there is a court expert, the court expert prepares a report. It goes to both sides. They're allowed to offer comments on that, and then the judge can do with it what the judge wants. But that's really not a particularly useful tool. At the district court level, that's about what you're going to get. You're going to get what the parties have put in, and you're going to get what the party experts have said. Once you move to the Court of Appeals, you enter, in some ways, much more dangerous territory, because at the courts of appeals, and certainly even more so at the U.S. Supreme Court, it has become very commonplace for people to file amicus curiae briefs. And we had quite a debate in the Seventh Circuit about this, because here's the problem. On the one hand, the amicus is very useful to put the case in a broader perspective, maybe to educate the judges about what the long-term implications of a ruling one way or the other might be. But on the other hand, the amicus is probably going to be relying on facts that were not part of the record in the district court. And we're very fussy about that. On appeal, I can remember saying to lawyers many times, you're arguing this fact to me, where is it in the record? Because we have a very strict line that says all the facts have to come into the record at the district court, the first instance level, and only later, you just can't add facts at the Court of Appeals level. So amicus briefs are filled with facts that are kind of designed to give you a perspective, but the judges are not really supposed to use those facts to base their decision on, because they haven't been tested in an adversarial way. And of course, we all know these days, what's a fact? I mean, you can go to Wikipedia on the internet, or you can go to some random website and it'll say practically anything you want. So we really do need to be very careful with our assessment of facts. And that's a weakness in amicus briefs. Another weakness in amicus briefs, and this is what's being considered at this point by the Judicial Conference of the United States, which is the governing body for the federal courts. It's composed of the 13 chief judges of the circuits, plus 13 first instance district judge representatives, and the chief justice chairs it. I actually sat on that committee for a while, the committee on the Standing Committee on Rules of Practice and Procedure. They're looking at the rules for amicus briefs because they turn out not to be broad enough for making sure that interests have been properly disclosed. So what they're saying is you have to indicate the identity of the amicus, its interest in the case, the source of its authority, and you also have to say whether a party or a party's counsel contributed money that was intended to fund preparing or submitting the brief. Okay, so far so good. You would want to know that. But what's happening instead is that certain parties contribute money more generally. So in the Google case, as we've seen, Google maybe gives money to the U.S. Chamber of Commerce. They're not earmarking the money for the preparation of a particular amicus brief, but it's a generous contribution. And so what we're struggling with is how can you capture that set of interested contributions, that set of interested parties? And should we require them to disclose if they've given any money, whether earmarked or not, to a participant in the litigation? Now, that's all well and good, and I'll just say there are a couple of constraints on the other side of that that we're going to have to deal with. One of them has to do with the right to proceed anonymously. So long ago in the 1960s, I think, 60s or early 70s, I think it was the 60s, the Supreme Court had a case dealing with the NAACP, the National Association for the Advancement of Colored People is what it was called. But it is and was a very reputable organization advancing minority rights. And a town in the South wanted them to disclose names of all of their members. And they were afraid that if they did that, there would be retribution of various kinds, possibly even violent. And it went all the way up to the Supreme Court. The Supreme Court said in that instance, they didn't have to disclose the names of their members. So the question is now, how far does that principle go? Because in our political campaign financing world, we require disclosure if you've made contributions above a certain amount. We could do the same thing with amicus briefs. And I would venture to say most of the time, nobody's going to get all upset because, you know, a big company gave money to the Chamber of Commerce or to the American Enterprise Institute or the Federal Society, whoever else they gave money to. I think that's not likely. But anyhow, that principle is going to be argued as we decide how much disclosure needs to be made. The other principle that is going to be part of this, I think, comes straight from antitrust, and that's what we call our Norr-Pennington doctrine. The Norr-Pennington doctrine says that the antitrust laws encourage people to lobby their governments to, express their views, even fairly, unfairly, or whatever. And so that conflicts a little bit with amicus briefs because the courts do regulate how many of them can come in, but this concept of your freedom to participate, I think, is also part of it. My thought, particularly after this big dust-up we had in the Seventh Circuit about this years ago, is this may be another area where disclosure is the answer to the problem. Because I could imagine asking an amicus to write a brief that very clearly identifies, based on the facts in the record, here's what we have to say. And then maybe another section of the brief saying, but we're going to offer you a broader perspective from our own experience, very clearly labeling that facts that are not in the record. More experience of, this member company had this experience and somebody else had that, and maybe somebody thinks it's very easy to support competition in a particular area and someone else doesn't. So I think disclosure is the most likely way of handling this. And again, as I said before, pretty easy probably to say, disclose if you gave any money, never mind whether it's earmarked or not. The last thing I'll say is just that we back all of this up by a very, very robust system of regulating the judges themselves. And I'm quite familiar with that because after 7 years of running the system for the Seventh Circuit as chief judge, that's what I did a lot of the time. So we begin by requiring the judges to disclose all interest they have. It could be a penny stock. It could be anything, but not just the judge's own, but the judge's spouse and people who live in the judge's household. So you've got to say who you're interested in. That way you could go back to the amicus brief and say, well, the judge has a stock interest in company X, and company X has decided to file an amicus brief. Let's think about this. If the judge is also prohibited from sitting on cases in certain areas. There's some statutes and also the Code of Judicial Conduct. And there's quite an elaborate process where any citizen can complain if they think the judge has violated those rules. The chief judge of the circuit reads that complaint, evaluates it, decides whether it needs a deeper investigation, and if it does, there's a whole process set out in the statute, which theoretically could even lead to impeachment at the end, although the only cases that I remember that came close to that were resolved when the judge in question resigned. But this is, the disclose, but also back up with rules designed to ensure integrity in the system is what we've done. So I think I'll stop there and pass the word back to others, but thank you for allowing me to participate.
Thank you very much. Just good. A couple of questions, if I may, with regards to amicus brief. Is it possible in the US system for the DOJ or the FTC to bring in, and will you have different perspective if the amicus brief is from the DOJ or FTC than if it is from, let's say, an association or some other type of university academics? So that's kind of the first question, because we have actually the possibility in Europe, for the European Commission to introduce amicus brief in some national courts. Yes.
Yes, absolutely, yes. At the appellate court level, Rule 29 makes it very clear that the United States or its officer or agency or a state, meaning like New York or something, may file an amicus brief without the consent of the parties or without leave of courts. In other words, there's just an absolute right for either the Attorney General or the corresponding authority at the state level to file a brief. And I can tell you, as the appellate deputy, which I was in the antitrust division many years ago, that's one of the things I did. Somebody would come in and they would say, "We'd like you to file an amicus brief in our case." And so we'd have a meeting, and then we would go off, they'd leave, we'd go off and study the case. And if I was persuaded that that was a good idea, what I had to do was ask the permission of the Solicitor General to file that brief, because the Solicitor General is the gatekeeper, for the Supreme Court. And actually for the lower courts too, there's Solicitor General governs whenever appeals are taken to the courts of appeals. And if the Solicitor General was convinced that this was, a good use of the political capital of the administration, the brief would be authorized. So there was an internal Justice Department process. But once that was over, then as far as the courts were concerned, the United States just had the right to file.
And the rules were the same as for other amicus briefs, in the sense that it was still considered only the things that were on the record, because eventually here, or is it broader?
That's right. The United States could not add to the record, and what the United States actually they are almost always very useful briefs. You can see them if you look at the website of the Solicitor General, and you would make clear the policy position that the government was taking. So take one from many years ago. Did the United States support the idea that indirect purchasers should not have a right of action? So, okay, yes or no? And the United States would state its position.
And the second question, I'm sorry I abused a little bit of your time. You mentioned that you don't appoint court experts, although there is this possibility of the civil procedure rules. Do you think that is eventually affecting the type of economic knowledge that is produced, in the sense that instead of the academics are focusing on presenting mainstream views, they are trying to signal that they are an antitrust dove or an antitrust hawk to be able to get hired by the parties, and eventually that is creating some false sort of incentive scheme in the world of academia?
I don't know. There are a couple of safeguards against that. First of all, one of the problems with the Fry test that you mentioned very briefly, which looked for expert testimony that was generally accepted, is, and remember, these rules cover everything. They don't just cover antitrust case in economics. They cover expert testimony that might come in a Food and Drug Administration case, or expert testimony that might come in an environmental case. There are all kinds of things that it covers. So the problem with the generally accepted rule is that you are almost by definition not admitting the cutting edge, really good research. Maybe think of the development of the COVID-19 vaccines as an RNA model vaccine, which had not been successful before that. Well, that wasn't generally accepted because it was new, and yet it was an incredibly powerful new thing. So you try to let the new stuff in, but you also try to make sure that the expert is a serious expert in the area. One of my rules of thumb was always, are you telling the court the same kind of thing you are working with day to day in your normal life, or is this sort of tailored for the case in question? Because if it's what you're doing all the time, I think it's more reliable. That's the advice you give to companies, or that's the analysis you put your name, maybe you wrote a book, that shows how the whole thing works. So I'm not that worried that you're going to wind up with fringe viewpoints. The judge may simply not let them in with the gatekeeping, and I think it'd be pretty easy for the other side to tear it apart in the adversarial process.
Well, thank you very much for this comment. So I'm now moving to Fernando, who has a huge litigation experience at the European courts, both of them. So he can talk about them to the extent that you can, of course, and also tell us a bit about what is on the other side. I mean, what are the tactics of the parties in these cases, and the exit you had to confront at the court. So thank you very much for anything you can share.
Thank you.
Yeah, you can use this one. Yes.
Okay. Thank you for the invitation. About the tactics of the other side, I don't know. I haven't been in the revolving doors, so but I do.
Have you observed them?
I observed them. I also observed the court. I was at the court many years ago. I cannot say negative things about the court because next time I appear, maybe I have to pay a price. So I will be just a bit describing some rules applicable to issues of conflict of interest, both generally in the Commission and at the Court of Justice. And making a number of reflections about the impact on litigation and a number of asymmetries that I will refer to a bit later. Just so that people are aware, there are of course in general staff rules which apply to the staff of EU institutions, both the Court and the Commission. Then you also have more specific instruments both at the Court and in the Commission applicable, that give more detail about these rules, be it about getting gifts, about post-retirement activities of when you leave the Commission or the Court, and so on. You also have, because the staff rules do not apply to the commissioners and to the judges, they have their own code of conduct, which is in the official journal, and which is a bit stricter, and it's logically, because part of the system is that the higher you are, the better you're paid, but also you have, of course, more restrictions as regards accepting gifts, because you have more responsibilities, and about, for example, restrictions on after leaving activities. That is, as I said, very clear. These rules, more or less, are in their structure quite similar. There are issues about declaring conflict of interest when you join the institution. Normally, that's not a major problem. You have to set out a bit, eventually, if there is something you have been involved in the past, in case of judges or commissioners, any money that you have, and so on. Then, of course, you have rules about accepting gifts or hospitalities while you are in office, external activities that you may have to do. They are more or less same, but of course, the idea is that your independence shouldn't be compromised. That means that you also have to declare every single thing. And there is a system eventually of refusing, eventually to accept some activities if they are considered that they have an impact on the performance of your duties or on your own independence. And then, of course, you have sometimes the tricky thing, obligation after you leave, which is the famous revolving doors. Again, the rules are relatively strict, quite strict when it comes to judges, when it comes to commissioners. concerns staff rules are a bit rather strict, but of course you have to bear in mind, we were discussing about that before, in the EU institution you have the permanent officials, and then you have people who have a contract, and after 6 years they have to leave. It's not that they want to leave, they have to leave. So somehow they need to make a living when they have to leave the Commission. So I'm not sure that you can apply the same principles in both situations. The missing part in all this a bit is that the rules are generally geared towards conflict of interest, where they focus on matters. If you are following a file, and they don't really capture so well, and it's one of the problems, of course, not so easy to solve. You may be influencing your policy views in the perspective about the perception of reality, what is going on out there, which is more ideological you want, and it's of course more difficult to capture. Of course, you're free to read whatever newspaper you want to read and the sources you want to read. That's a bit, of course, some of the rules by preventing, for example, receiving gifts and so on are geared towards precisely not being influenced. But very often you see that it's being influenced in some type of decisions, specific decisions. Eventually, a company that is involved in a case cannot, of course, be at the same time, of course, paying you a trip or anything. So that's part of the things which are, I wouldn't say missing, but obviously it's more difficult to capture in rules. As I said about revolving doors, maybe a couple of words about that. There are, now talking about the Commission, sometimes it is in the news, there is a lot. I don't think there is so much. I mean, in some cases, I was saying, for the lower ranking people, you have a contract, it expires and you have to leave. It's not that you choose to leave, and people obviously don't make a difference. There are in the competition a bit more of those cases. I know more of this phenomenon among economists, among lawyers, not so much. Actually, in the legal service, we don't have an issue about that. I think the last colleague in the team who left for law firm was 18 years ago, and he actually came back after 4 years. So it was not, people are so happy in the legal service, nobody wants to go to a law firm. I think the ECOM is full of more ambitious people, I think, than in the legal service. And then, therefore, this phenomenon happens a bit more often. But again, I think overall, I know many people in ECOM, that's really a tiny fraction, the people who will, at one point in time, before the retirement, because if you retire, you want to stay active, it is another matter. They will go and move to a law firm or a consultancy. So I think there is a bit of an exaggeration, and in some cases, as I said, it's people who have to leave because the contract is over. So there is no so much revolving door. The situation of the court is a bit trickier. Of course, the judges, as I said, have a very strict code of conduct. They also are very well remunerated even after retirement. The same thing for the commissioners. But of course, the issue sometimes is about the referendars. That is actually, talking about the court, there is a new decision a year ago about the Code of Conduct for Ethics, which is stricter than the one that was adopted some 7 years ago, I think, with some specific chapters on referendars and so on, because those are posts which have a few influence in the debate. They help the judges. And at the same time, typically it's a temporary post. So yes, these people will have to leave later on. Some people stay there forever. They are referendars for different judges their whole career. But that is a bit of an issue. Another thing that is a bit missing in all these rules, maybe, and it's very difficult to capture, it is member states. In some of the competition cases, of course, we have transparency rules about not meeting private parties. You have to report it. Nowadays, this obligation has been extended to even heads of unit, to myself, if I ever have, or if I meet in the context of a specific procedure, I don't have to sort of declare it, because, of course, if you have a merger case and you meet with the lawyers of the merging party, you don't have to declare it. But somehow there is the idea that, if it's a private or a lobby, that's but in merger cases, in competition cases, every now and then you may have calls from member state. How do you capture that in your independence? Of course, the rule is very clear. That's in article, I think it's 11 of the staff rules. It's also in the treaties, You cannot get any direction, any instruction of member states and so on. But it is true that somehow people are very worried about corporate influence, but there is also the public influence. A member state who is trying to push for a merger, for example. And the rules are clear. You cannot get an instruction, but certainly you have to accept the call, maybe. If a minister is calling you, you are not going to say, no, I don't want to talk to you. So, and there may be other types of rewards which are not purely financial. Maybe a minister is promising you the vote in your next job if you want to apply for another job. I don't know. I mean, I'm speculating here, and don't think. The thing is, it is something that obviously may, and it's very difficult to regulate. Let's face it. I will talk about the litigation and the asymmetry as I see it. There are, of course, big asymmetries in some types of litigation. You have, on the one hand, a small group of very motivated officials, 3, 4, 5, 6, both the comp and when it comes to litigation, the legal service, and on the other side, a much larger amount of people, because of course, with deep pockets, you can have 35, 40 people working in the case. In general, also in the public debate, as I think was explained before, the interest of dominant undertakings, in particular big corporations, is far more concentrated, and therefore somehow there are other interests which are not fully represented. I think they were very clever in that 20 years ago. They went for the consumer welfare, and then there was this idea that actually what they were doing was also good for the consumers. So somehow the two sides were somehow represented in the picture, and there was no imbalance. I think nowadays we realize that was not always like that. But I think the problem in litigating nowadays is that when I go back 29 years ago when I started litigating, you were litigating through the pleadings. I mean, it was what you wrote and what you spoke during the hearing. Nowadays, with the internet, with the blogs, you have a case, and I don't know, there is a hearing, people start writing, having opinions about cases. By the way, most of the bloggers, they don't even know what they're talking about. In the sense, they don't know the facts of the case. When I read some of them, the case is not really about this, because they have a very partial view of the case, obviously what is publicly available, which is normally a very limited amount of information, and still they want to express a view about that. When you have the opinion of the advocate general, you will have those who do not like it that will try to explain in a blog why the judges shouldn't follow the opinion. Of course, I cannot do that. That's against our ethics, to start and write in a blog saying, the judges should follow it, or something like that. So it is a bit unbalanced in the sense that you are not only fighting in court with the arguments as put forward and the facts as put forward in the file of the case, you're also arguing in the court of the public opinion, or, public opinion is not full public opinion, but you know what I mean. So you have to engage every now and then, in some debates, if there's a workshop or something, just so that at least the debate is not monopolized by the other side. But as I said, I find it very troubling, all these people who are writing about the advocate general opinion, why, in reality they're pleading, we don't have amicus curiae, but this is sort of amicus curiae. But the thing is, of course, it's always very one-sided, because typically it's mainly those who are critical of the opinion who will write something about it. Those who like it, obviously, they're not going to write a post to say, I love it. So that's how it works. So that is, I think, an asymmetry which is quite important. About experts, at the court, very much as in the US, we don't. I mean, last time a court-appointed expert was actually appointed was in the Woodpal case 40 years ago. It's not done anymore. So basically, insofar as it is about economic expertise, then each party, the commission will go there with the evidence we have. The other party will have partisan evidence, so to say. What I find troubling sometimes, of course, each judge is completely different, so you cannot just generalize. You have different kinds of judges. Those who are a bit more normally will find that the institution has some credibility in the sense that you act in the public interest, but they also have this attitude of saying, the same thing. I remember a couple of workshops where someone was accusing the commission of bias. I said, well, and the idea is, okay, maybe we are biased because we are defending the applicant. But the commission is also biased. So one is biased, the other one is biased. You have to, rule in the middle. So if there are 6 cases in court each year, we have to win at least in 3 cases. And the commission must go 3 cases because, okay, since both are biased, I cannot accept that as a matter of principle. I mean, because when we try to do our job, we may get it wrong. It's not that we don't make mistakes. But certainly you try to do your best to be unbiased and act in the public interest. And there are actually guarantees about that. There are rules about that the applicant doesn't have, but we do have. So when I find, and of course in social conversations with judges, you see some understand it, but other judges, they appear to think that you're a plaintiff and therefore, you're the commission. I'm not going to give your economists more credibility than the credibility of the consultant of the applicant. And that I find it a bit troubling, because that's not how the system is supposed to work. In any legal system, if you have the expert of the police, it has a lot of credibility, even if it's the public authority and it's a party to the case. Whereas I have the feeling that somehow, through 20 years of somehow presenting the Commission as biased, I don't know exactly what it means, okay, since both are biased, at the end you have to decide in the middle, so you have to win a few cases, otherwise you are not being fair somehow. And I find this sort of, at least I'm happy that in the study you've done, the credibility discount for sort of public experts is a bit lower than the credibility discount for private experts. So I think I will stop there. Eventually, there are questions I can elaborate on some of the issues I have.
So, thank you very much. I obviously take the point about the social media legal and economic commentary almost a day after. Immediate. I mean, it's almost like it's done. And I hope I don't know, maybe these are billable hours, you think, or not? I mean, to write these social media comments. And have the social media wars, occurring between the various experts in the field. Some actually lawyers are specializing in that recently. I mean, almost every important case, there's a nice commentary the day after, even the same day, on some social media. But let's turn now to, because you raise the issue about, how much of discretion, how much, I'll put it under discretion, but maybe it's strong. The courts recognize the Commission as being the institution that, is public interest motivated, brings a case, and of course we have a manifest error of appreciation. So, but then, it's a judicial review process, and if we move to a setting like the one in the UK that I would like to move now, and the CAT, where you have an appeal process. So it's not exactly like the judicial review. Let me also say, but the three of us here from the CAT, we're only presenting ourselves and we're only expressing our personal opinions today. And obviously everyone else here. So I want to turn to John, basically, who is an economist, is a member of the CAT, but also I think I would like him to share also his experience as a member of an international organization that is also pretty active in guiding the debate in competition law and policy. I have to say that from my past time as a head of authority, I mean, sometimes some of us have been concerned about the choice of experts invited at the OECD meetings, how plural that was, how different views were represented, and I think it's something that also to watch very carefully, and certainly many of us are watching still now and will be watching in the future. John, any comments from the economists, CAT, plus OECD perspective, only expressing your own personal views, of course?
Indeed, of course. Thanks, Ioannis, and thanks for inviting me. Look, I think I'll probably only deal with the first half of that, given time, quite enough to talk about from the CAT side. Happy to pick up OECD if there's any chance of discussion later. But in any case, there isn't a very fixed process at OECD. Stuff kind of emerges. So for the CAT stuff, as you said, can't speak for the CAT, nor can I speak even about my cases at the CAT, because they're all ongoing. But my perspective on this comes to some extent from looking at a lot of previous CAT judgments for a paper that I wrote for the Tribunal's conference 2 years ago that you were kind enough to reference in your paper. At the time I wrote that paper, I was actually a consultant for Compass Lexicon, but I knew I was joining the CAT, although I wasn't actually able to announce that. So in a sense, one has the sort of opposite strange incentives from when someone is leaving public sector to going to the private sector. But I had it in a way which I hope is somewhat less biased. I knew that I was going to be a member of the CAT, but I couldn't tell anyone. But I wrote it with that perspective. And what this paper is trying to pick up is the way in which expert evidence by economists at the CAT goes well and when it goes badly. And I think the areas that I was discussing there, and there have now been some discussions within the CAT about that since. And there may at some point be a publication from the CAT, some sort of guidelines to economists or a practice direction, but I don't know anything about the sort of formal process there. But there has been discussion amongst economists at the CAT since then along these lines. It's sort of at a lower level, I think, than some of the discussion that we've had today. But I'll say what it is. I mean, let me put it this way. Very crudely, I can think of two ways in which you could think about what an expert witness is doing. Sometimes they're giving an opinion, and sometimes that's all that you can expect them to give. If a nuclear physicist appears in front of us and says, this is the relevant bit of nuclear physics for your case, and you can believe me on that because I'm this professor of nuclear physics and that sort of thing, then that's an opinion where credibility is what's going to decide it, because we're not going to get into trying to understand what the right answer actually is. If there are competing opinions, we'll decide them according to which one of those we believe. I think most of the time, certainly at the tribunal, perhaps because we have economists like me on the panels, that's not what expert witnesses for economics or for financial matters, accountants, are actually doing. They are much more, how can I put it, presenting facts. I mean, I don't want to sound naive about that. Obviously, there's no such thing as opinion-free facts, and you hope there won't normally be any fact-free opinions either. But when somebody sort of puts in, ultimately, shall we say, thousands of pages of expert report to the tribunal, and Tomas is absolutely right, there's far too much of it, they're not spending that thousands of pages talking Arrow versus Schumpeter, talking big conceptual economics. They're going through lots and lots and lots of little gritty bits of evidence and presenting those, maybe in a motivated way, maybe in a way which is misleading. And what I am concerned with, and what some of my fellow economists at the tribunal are concerned with, is trying to improve sort of that process, if you like, of that presentation of quite low-level, shall we say, factual material. I mean, to give an example, so I worked on these multilateral interchange fees as well. But when I was at Compass Lexicon, I was instructed for a number of retailers who were claiming damages from MasterCard, so acting for the claimants. But, I talked a little bit about Rocher and Tyrrell, but I mostly wasn't at that kind of stratospheric level. I was doing the cleaning up exercise sort of after those discussions had already happened. A damages claim, and for the damages claim, one wasn't discussing this sort of high theory. You were looking at individual natural experiments. I mean, the Brexit example that Tommaso talked about would have been a good one if it had happened at the time, but for example, we were looking at Australia, and in Australia the MIFs had been capped, so you looked at what happened there, and then the MIFs were also capped for American Express, which was of enormous interest to that particular damages claim, and so you looked at that. And there were maybe 5 or 6 publications that talked about that. They weren't necessarily publications in academic journals. Some of them were, some of them weren't. Nor were they necessarily directly concerned with the question that was at issue in the trial. And that's actually quite common. I mean, when I think about places where, whether in the public sector or the private sector, I have found useful bits of evidence for something I'm looking at, it's often in academic papers that are actually concerned with something else completely. You find a paper that's looked at some industry and you get a price elasticity of demand from it because they've gone off and estimated that using data. The paper's going to be about farm subsidies, or it's going to be about advertising. It's not going to be about the competition issue in front of you. So there is all of this kind of day-to-day stuff going on. And in all of this stuff, as people who will be familiar with the sort of concerns about the replication crisis in social sciences will know, there are various ways in which either conscious biases or unconscious biases can affect the way these sort of supposedly factual matters are presented and interpreted. It's selection of data, it's whether you exclude outliers, it's getting more sophisticated, the specification of econometric equations, and so on. And there is a great deal of opportunity for a consciously or unconsciously biased person to introduce, through motivated reasoning, a particular slant upon that. And I think what we're interested in is trying to get a handle on that. You mentioned appeals and public bodies. I mean, just again to illustrate the point, that we're not necessarily interested in at least I'm not necessarily interested in assessing the credibility of different experts. One of the things we've noticed in recent years is that the CMA has started putting forward independent experts when it's under appeal. Tommaso is one, Jonathan Baker was another. I have to say I don't see a great deal of point in that. If I were hearing, and I really am not speaking for the CAT right now, but for me, if I were hearing an appeal against the CMA's economic analysis in the case, I'd want to hear from the chief economist of the CMA. I'd want to hear from the CMA economists who worked on that case. Will they be unbiased? No. But I'm not interested, if you like, in whether the economist says the CMA was right or the CMA was wrong. We're interested in getting down inside the analysis to actually determine what the real answer is. I do believe there is such a thing as real reality in the way that we sometimes say to 5-year-olds, do not ask who was right, ask what is right. And that's, I think, what we think we're trying to do. So some of the sort of thoughts we've had, we, not the CAT, me and a few economists I've spoken to at the CAT, about ways forward, are around interpreting the duty of experts to the tribunal and maybe clarifying some of what that means. One thing that I think is particularly interesting and potentially useful is what I call a duty of curiosity. There was a case a couple of years ago, DAF Trucks, in which one of the experts came in for strong criticism. Now, one of the reasons that he was criticised was because he'd had a previous relationship with the company he was instructed by. And that may or may not be a problem in itself. And by the way, that's Damien Nevin. I'll mention that because I was at Compass Lexicon at the time, so he was a colleague, but I didn't work on that case. But there is another problem which the judgment identifies with that, which is you've been working for this company for many years, Professor Nevin. There's various things, therefore, you ought to know. How come, all of a sudden, when it comes to why were they pricing like this, why were they talking to their competitors, why were they doing these things, you say, well, I look at economic theory and I can't think of a reason why that happened. If there is a duty of curiosity, it means that expert economists cannot, if you like, hide behind very narrow instructions to say, I can only look at this bit because that's where I've been instructed. So that might be part of it. Other things that might be part of it, more active case management, more use of the joint meetings and hot tubs. People have talked about hot tubs already. But more generally, transparency of data, transparency of research methods, pre-commitment to some of the methodologies in a long trial so that economist experts are expected to explain how they will interpret data before they have actually done so, before they have actually looked at the data. Again, these are things that the social sciences in academia are very interested in. So none of that really speaks to the sort of high theory Tyrol points, but actually the day-to-day work of courts when they're dealing with expert economists, I'd suggest, is actually much more in that kind of area of examining gritty factual bits of evidence and trying to decide what's actually going on underneath. And that's the area that we've been interested in.
That's very interesting, John. And in particular, I mean, this focus on the specificity of the UK system, this duty to the court, that is absolutely important. And also, we don't have the Dober tools, but we have admissibility step in the analysis, of course. And then we know in terms of substantively, I mean, we're also using this concurrent evidence type of hot tubbing procedure to enable basically take out the lawyers, take out a little bit the more conflictual part, and have the experts have a discussion between colleagues about specific issues. Simon, you have been serving at the CAT more than me and John, so you have more experience on these type of cases. So maybe you can share some last views on this topic.
Yeah, happy to, and particularly to avoid duplication with John, just a couple of comments on things that colleagues have already mentioned. Damien talked about the independence of the members of the college at the Belgian Competition Authority. So I thought a couple of words about the independence of members of the CAT. We have some, 20 or 30 members of the CAT who, like John, Ioannis and myself sit alongside a High Court judge, and we have a fixed term of appointment for 8 years, and that is non-renewable to protect the independence of the members. In each case, the members, the judges who are going to decide a case, are selected on various criteria, one of which is that there is no conflict of interest, and that's one of the reasons why we have a large pool of potential members. And then thirdly, we are not allowed to advise on competition law, not allowed to advise commercial parties anyway on competition law matters. So there's at least 3 points to reduce the possibility or potential for conflicts of interest. And the other thing I thought I'd make a preliminary remark, Ioannis, you mentioned the training of judges. That is something we are very sensitive to. And one of the advantages we have at the CAT, because we've got people within the CAT who are experts in finance, economics, law, competition law, and so forth, we do nearly all our own training in-house, and we're very reluctant to have external people. I've known a few exceptions to that, but one academic came, and we had somebody who could speak to funding with that expertise we didn't have in-house. But 90% of our training is done internally. And also, somebody mentioned the Association of European Competition Law Judges. They too are very sensitive to having external people. And I know from personal experience, I've suggested somebody who'd be good to speak to them and said, no, that won't look right, even if there wasn't a formal conflict of interest. But turning now to a few points from my own experience, I think the most obvious situation where I personally have seen the potential for a conflict of interest has been when we've had a third-party submission in a case, an intervener, as we call it, which appears to be independent, but when you look at it, you really do question how independent they are. The highest profile example of that was the Meta-Giphy merger, where the CMA had blocked Meta's acquisition of Giphy, and there was an application to us in relation to that, and there was an intervention by a body called the Application Developers Alliance, or ADA, which said they were independent and explained how, as a completely independent party, the CMA was completely wrong to block this sort of a deal. But when we looked at it, and as the CMA naturally pointed out to us, the body was very closely aligned with Meta. Meta was no longer on the board, but it was very much very close to it. The case had been discussed with Meta. Meta had offered to pay their fee, the costs of the intervention if necessary. What we did there was to let them in as an intervener. We had paper from them. We said we would only hear from them if that was really necessary. And then, shall I say that we gave appropriate weight to what they had to say. That was in our discretion. The other area I was going to mention, and John has touched upon this, which comes out often, and that's where the CAT has been concerned about the independence of experts. Not vis-à-vis third parties, but vis-à-vis the party who is paying them. To what extent are they really just an advocate for one of the parties? As John has said, the experts owe a duty to the court. That is in the rules of procedure, and every expert opinion that we receive, it starts off by explaining, I understand that my primary duty is to the court and not to the person who is paying me a fee. Personally, and I really am speaking personally here, I don't get too hung up about that, because I treat them as an advocate like I would treat them as a lawyer. And apologies, and that is, in other words, I treat what they have to say with respect. I'm interested in what they have to say, but I don't really pretend that they are independent. I see them as an advocate. And after all, and I was interested in what Aviv said about the apoplectic judge who said that everyone has a bias, and that's how I treat them. They are there for one party, and when people try to make distinctions between lawyers and economists, you have to bear in mind that the lawyers also have a duty to the court. They have a duty to disclose judgments which are adverse to their case. So it's not black and white, lawyer, advocate, economist, independent opinion, expert. I was going to give the example of that of the Royal Mail, but John has touched on that. So I'll just he mentioned the concerns over the failure to disclose things and the lack of curiosity. They failed to ask the right questions, some of the obvious questions. But how did the court deal with that? They said that they didn't formally see that as a conflict of interest, but they said this undermines his credulity, and we have to be cautious about taking what he says at face value. And reading that, I was reminded of what the Stigler report says about there being a 30% discount in relation to conflicts of interest. And one can only speculate. Did they give his testimony a 30% discount? Feels about right, but that's totally without any evidence. I say that. The most obvious concerns with the conflicts of interest is indeed with economic experts and economic evidence. One issue is you be frank about it, treat them as an advocate. That's my own personal approach. The second thing that I think protects against that is the fact that we are a specialist tribunal, and whenever we're getting economic evidence, we'll invariably have our own economist on the panel, somebody with the experience like John. The hot tub process is another way in which that might be mitigated. But also, I think the other point to bear in mind, and here I speak as the lawyer, is that the economic evidence is only part of the evidence. As Sir Marcus Smith said in an article, this economic evidence goes into the pot with all the other evidence. And as such, that gives us the potential to factor in, if we know about it, the potential conflicts of interest there. In the Britnegg case, which wasn't before the CAT, but it was a competition case, Sir Marcus Smith rejected the claimant's economic evidence, referring to the fragility of the model and that it didn't fit the qualitative evidence. That's perhaps an extreme case, but normally it's a question of balancing the two. Another comment he makes to mitigate against this, that the economists are of a very high calibre that appear before us. They are indeed, but doesn't that create its own problems? Because many of the very best economists are going to be regularly employed by the corporates with the biggest pockets. I don't know what the answer to that is, but I just sort of throw it out there. Two other quick points. Well, no, perhaps I should say that although I've mentioned economists, we have similar issues out in the external world. I mentioned economists, I think, because we have the economists before us more frequently than anybody else as experts. The lawyers are there as advocates, and we know they're advocates. That's quite out in the open. But in the wider world, and Ioannis has referred to this, we're well aware, and so has Fernando, we're well aware that there are legal articles out there and posts on LinkedIn that we all see regularly, which are quite, certainly in our view, self-serving, and we put appropriate weight on them. If I may, I'd like to make just two comments in relation to competition authorities' recent statements, only because my colleagues haven't mentioned them, and I was curious about them. One is a statement by the Commission recently in November, telling environmental non-governmental organisations that they could no longer use monies they received from the EU Green Deal for advocacy. And this affects, I think, the income streams to bodies like WWF, Friends of the Earth, and so forth. I mention that because that was seen prior to that as really something which was balancing corporate lobbying interests. It's not a competition-specific point, but I think it's the underlying theme, I think, here is often, certainly Ioannis, in your work, is how do we counterbalance perhaps what's seen as the over-influence of corporate bodies. And finally, the FTC made an interesting statement 2 weeks ago, which said that FTC officials, or certainly senior officials, were going to be banned from holding leadership positions in the ABA, from participating in the ABA events, and renewing their membership. Now, there is a positive side to that. I mean, initially one thought one was suspicious of it. There is clearly a positive side to that, in that the ABA is dominated by defence lawyers from the big law firms representing big business. So being alongside the FTC officials gives rise to concerns about big tech capture of the ABA, and generally the cosy relationship with those perhaps after leaving the FTC to join big law firms. But that in it, looking at it objectively, seems quite positive. But on the other hand, there was so much politicising in that I must admit I got a bit suspicious, and I don't know where I finned up. I couldn't believe it when I actually read the letter. I read the press statement, and that thought, that's interesting, good. I read the underlying letter, though, on the train this morning, and there was a rant about the leftist democratic agenda. And the FTC, what's it going to do? It's going to do some good competition things, and it's going to focus on helping Trump usher in America's golden age. Yeah! Should that undermine my positive view of what they actually said? I don't know. I'll finish on that sort of rather provocative remark.
I hope it does.
All right, thank you. I think we'll finish this panel with this provocative remark because we're already pretty late, and I hope we'll have the opportunity to discuss later. So and have questions eventually also for the things that were mentioned in this panel. Let me just thank a lot my colleagues for their very, very interesting remarks. We cover a lot of ground. We're going to have like 7-8 minutes break for stretching out, and then coming back for the final panel, the judicial legato.